The Miranda warnings are: you have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present with you during questioning. And if you cannot afford an attorney, one will be provided for you. The Miranda warnings apply whenever a person finds him or herself in what's known as custodial interrogation. So let's break that down. First, 1, custody. You have to be in the custody of the police, whether in the back of a police car, in a holding cell, in an interrogation room. You have to be detained and not free to leave. Second, interrogation. The police have to be actively interrogating you or asking you questions that would reasonably elicit a response from you. Any spontaneous statement that you make is not going to be considered within the purview of the Miranda warnings because there was no interrogation. Anytime someone is in this custodial interrogation, the police have to give the Miranda warnings. Now, the Supreme Court has held that when you are requesting an attorney or you're, saying that you want to remain silent, that you have to expressly and explicitly indicate that when you're talking to the police. You can't be vague or ambiguous and say, well, maybe I should get a lawyer, or it's probably a good idea to call an attorney. No, you have to be explicit. I want to have an attorney present with me during questioning. I'm not answering any more questions. I do not waive my Miranda rights, and I'm going to invoke my right to remain silent. It's important to remember that. Never waive your Miranda warnings. Never freely agree to speak to the police or volunteer any information that can be used against you, especially when you're a suspect. I don't mean this to advocate that you shouldn't cooperate with the police in an ongoing investigation as part of your civic duty, but under no circumstances when you are a suspect should you ever volunteer any information or speak to the police without having an attorney present. No, you should never allow the police to search your vehicle, or your person, or your house. Now, under the Constitution, the Fourth Amendment to the United States Constitution, or Article 1, Section 12 of the Florida Constitution, we have rights against unreasonable searches and seizures, which generally means that the police must obtain a search warrant or an arrest warrant supported by probable cause, by oath or affirmation, before they can search you, before they can search your vehicle, or before they can search your home. Now, exceptions do apply, especially in the context of vehicles, because vehicles travel on the public roads, and it gets into an expectation of privacy analysis. But let's just say they don't always have to have a warrant to search your car. They can do it with probable cause. But a lot of times the police will just come up to someone who's been pulled over and ask, well, do you mind if we search your car? The police don't have to tell you that you are allowed to refuse, or that you can say, no, I don't want you to search my car. And more often than not, people consent and say, yeah, you can search my car. And I can't tell you how many cases I've seen or had where someone consents to a search and they find drugs or paraphernalia or some other kind of contraband in the car. And so suffice to say, never allow the police officer to search you, to search your vehicle, or to search your home. Always request that they get a search warrant and never give your consent. My name is Kevin Vagovic. I'm a Daytona Beach attorney practicing criminal law, family law, and civil litigation. Visit us on the web at vagoviclaw.com or give us a call at 386-265-0900.